Hello guys, I am back with another landmark judgment today. That is the Bangalore water supply case. Bangalore water supply versus R. Rajappa and others. 1978. So what happened in this case? R. Rajappa and other employees of the water supply company were fined by the Bangalore water supply appellant board for misconduct, and a lot of sums were recovered from all the employees by the board. Now, R. Rajappa and all the other employees, they filed a claim application under Section 33C, subsection 2 of the Industrial Disputes Act 1947. And they said under the claim application that they were imposed, that the punishment for the fine imposed on them was a violation of the principle of natural justice under the application. They said this. Okay, so what happened? Now the board raised an objection that they are not in industry under the Industrial Disputes Act 1947. That is, the definition of industry is provided under the Act under Section 2, subsection J. All right. So the board said that we are not in industry under the Act only. So hence consequently they also said that the employees of their company is not they are not workmen, and the act is not applicable on them, and the labor court had no jurisdiction to decide the claim, and the whole matter the labor court cannot decide because they are not covered under the Industrial Disputes Act. All right, so what happened? The objection that was raised by the board was overruled, and so the board filed two writ petitions in the Karnataka High Court. Now, the Karnataka High Court also dismissed the petitions and said that the board is industry. It is covered under the Act. So, hence, all the rules and regulations will be applicable on the board. This is what the Karnataka High Court said. Now, what happened next? Now the appeal by special leave was placed before a larger bench for consideration in order to sort the confusion for the definition of industry. There was a confusion whether what is to be covered under the industry and what is not to be covered. The definition was not clear and there was still a confusion. So it was placed before a larger bench to be decided for consideration of this. Now, what the bench gave out was a triple test for the industry. It said that these three things, if they exist or they are applicable on a particular organization, then that organization will be considered as an industry under the Act. Now, what is the triple test for the industry? I will tell you that. So, this triple test established under the case said that if there is a systematic activity going on in the organization, or the second, the cooperation between the employer and the employee, then third, the production and distribution of goods and services calculated to satisfy human wants and wishes. All right, so if these three things are happening in that organization, then that organization would be considered an industry under the Industrial Disputes Act 1947. All right, so it said, okay, so under the same judgment, it was also said that the universities were held to be excluded since the teachers are not workers. All right, so but the non-teaching staff, they said that they are included. So what happened was, so the judgment said that the teaching staff will not be considered as workmen. All right, and the non-teaching staff, they would come under the scope of the Act. So if there is any organization that comes under the scope of the industry, it is not necessary that all the employees of that organization all the rules of the Act will be applicable on all the employees. So if there are employees that are, for example, I have taken already an example of the university, that the teaching staff are not workers, whereas the not teaching staff is the worker. It is a workman under the Act. Hence, the law will be applicable only to the non-teaching staff, not the teaching staff, as they are not workmen under the Act. All right, so yes, so this is the triple test that came out under the judgment that was provided to figure out whether any organization, or any organization is an industry or not. That's how you can figure out. Now what happened, so but still there were, in a lot of cases after this judgment also, the question arose whether a particular organization was industry or not. So in 2005, uh, Justice Hedge Bench was there, and it sat and it referred it referred a particular case to a higher bench for again deciding the same thing, that whether a particular organization was an industry or not. So this case was the state of UP versus Jaybir Singh case. Sorry. So under this case, a higher bench sat, and they also gave a conclusion, and they supported the 1978 judgment, whatever was laid down under the Bangalore water supply case, the first case I've been talking about. It supported the judgment of the Bangalore water supply case 1978. All right. But okay, so it does not end here. The question before this case, state of UP versus Jaybir Singh, was that whether social forestry department of state, which is a welfare scheme uh, for improvement of industry, would be covered under the section 2 subsection J, subclause J of the Industrial Disputes Act or not. So this was the question that arose in state of UP versus Jaybir Singh. All right. So, and the conclusion was yes, yes, that is an industry. All right. And therefore, and no amendment was made to the definition of the word industry under the act. Now it is still, it there are so many cases in which the same question has arose, and people, we are looking for a change in the definition of the word industry, as there is a lot of confusion because of it. We are hoping that the definition would be amended. Now the Supreme Court would recently, now it is in news nowadays that the Supreme Court would soon be sitting, and they would be deciding whether the definition of the word industry under the Industrial Disputes Act needs some amendment or not. So yes, so this case has recently again come up in the news. That's why I thought we should talk about this case. Alright guys. So yes, I think that's all. That's all for today. I'll come back with another case soon.